In a powerful rebuke to Donald Trump and his imperial, king-like attempts to overthrow our democracy and our co-equal branches of checks and balance system, Judge Beryl Howell, senior judge of the D.C. Circuit Court, who once presided over aspects of Donald Trump's criminal charges and criminal prosecutions, has ruled that he will not be able to overthrow over 100 years of precedent, historical precedent, constitutional law, in order to fire whoever he wants from independent boards like the National Labor Relations Board, set up by Congress, so that the people of it couldn't be fired without restraint by the President of the United States. She is not going to stand idly by and allow the coronation of a king masquerading as a president of the United States. I'm Michael Popak. You're on the Midas Touch Network and Legal AF. Gwyn Wilcox was appointed to another 5-year term on the National Labor Relations Board. That's the quasi-judicial independent body established by Congress to address labor disputes coming out of an era in the 1930s when workers and unionized workers were often violently attacked and had very little rights in the workplace. National Labor Relations Board was established, and it allows for the president to pick the chair, but not to fire any of its members. In fact, in the last 90 plus years, no president other than Trump has ever tried to fire a member of the National Labor Relations Board. Gwyn Wilcox, by the way, is the only African-American member of that board. She did nothing wrong and under the Congressional Act establishing the NLRB. In order to remove somebody like Gwyn Wilcox as a commissioner, you have to give her due process, a hearing, and you have to show that she's conducted some sort of malfeasance or misconduct. Donald Trump just said, "Thank you for your service. I'm replacing you." That's not enough. Let me read to you, though, from some powerful, powerful analysis by Beryl Howell, who gives us an entire historical interpretation of the battle for the soul of America right now that's going on between those who believe in the imperial unitary president model and those who believe in checks and balances and a role for the federal courts in interpreting law and the role of Congress. And you know which side Beryl Howell comes out on. But let me read to you from a few pages of powerful, powerful analysis here, including a footnote that's a direct attack on Donald Trump, as well it should be. On page 4 of her order, it says, this is now referring to Trump, a president who touts an image of himself as a, quote, king or a, quote, dictator, perhaps as his vision of effective leadership, fundamentally misapprehends the role under Article 2 of the U.S. Constitution. In our constitutional order, the president is tasked to be a conscientious custodian of the law, albeit an energetic one, to take care of effectuating his enumerated duties, including the laws enacted by the Congress and as interpreted by the judiciary. In other words, we have a role as Article 3 judges. At issue in this case is the president's insistence that he has authority to fire whomever he wants within the executive branch, overriding any congressionally mandated law in his way. Now, she cites for he wants to be a king or dictator. This is footnote 5. Look at what she cites, taking Donald Trump's own words. She says, first, see at White House on X, February 19th, 2025, long live the king. We'll put it up here. That's the now infamous photo of Donald Trump mocking and trolling New York when he decided to get in the way of how they're going to fund their mass transit through congestion tolling. And he called himself the king of New York. So she threw it back at him there and said, we know you want to be a king. Then she quotes to a Wall Street Journal article. Trump says he won't be a dictator except for day one. She then quotes to a Trump posting on February 15th, social media posting on February 15th, quote, he who saves his country does not violate any law, to show he is maniacal, egomaniacal, and out of control. She continues that some of the defendants' supporting briefs, amici, also draw analogies to the British monarchy. Tennessee has described the tradition of the British king's prerogative power to remove executive officers at will. In a democracy, she continues, Beryl Howell, It was created to repudiate this very regime. That analogy has little purchase. And so she starts out, before she even gets to Gwen Wilcox and the NLRB and the history and the historical precedent and all of that, she starts with what is the battle for the soul of our democracy and our rule of law and our constitutional republic right now, which is this battle between those on the far right who argue for a unitary executive theory, that all power rests in an imperial president. They even use those terms. And that's people like from the scholarship, like Calabresi. And Calabresi, which everybody sort of follows in the alt-right world, he's written a lot of law review articles about it. He said that we've been imperial presidents from the very beginning. On the other side is the more reasoned approach by people like Lawrence Lessig and Cass Sunstein, who say the imperial president, unitary president model is a myth. And so that is what the tug of war that's going on right now. Judge Beryl Howell starts with an entire analysis. Let me take you to the merits of this particular case as she goes through how the NLRB was even founded. I've talked a lot in prior cases about a seminal Supreme Court case that's often cited about federal removal. President removal of federal officers, Humphrey's Executor. It's a case name from 1935 dealing with Hoover and the removal of a Federal Trade Commission representative, establishing the precedent that's dispositive today, as every judge so far to address the issue has said, that a president is stopped from removal without cause if Congress has established an independent a quasi body of independence to handle a certain area, and they've said you can't remove without cause, then you can't remove without cause. And that every time the Supreme Court has had an opportunity to reaffirm Humphreys over the last 90 years, they have. They did it in 1958, according to Judge Beryl Howell, in 2010, and in 2020. And Donald Trump to argue that Humphrey's Executor is no longer good law flies in the face of over 90 years of historical precedent that courts have applied, and even this Supreme Court. Now, what they counter with on the Trump side, of course, is the immunity decision, that gift that keeps on giving of Justice Roberts from July, in which he said in a criminal context, there's a lot of things that the president can get away with that won't be prosecuted as a crime. And they say that gives him the power, unlimited power to fire people. And Beryl Howell fires back and says that is absolutely nonsense. In fact, on Humphrey's Executor, she reminds everybody that the NLRB, the National Labor Relations Board that's at issue in this particular case I'm reporting on, was founded just after that case. 2 months later, Congress founded the NLRB. So we have to assume they knew about the Supreme Court precedent of Humphrey's Executor because it was only 60 days earlier. And yet created a new independent, quasi-independent board to handle a certain area. Yes, it exercises a certain amount of executive power. Yes, it's ultimately placed in our hierarchy within the executive branch, but that doesn't mean that Congress can't put limits on the president's power to fire people. Here's what Judge Beryl Howell says on page 10. Which kind of summarizes her holding. In the 90 years since the NLRB's founding, the president has never removed a member of the board. That's the powerful historical precedent that she talks about. Trump's attempt to do so here is blatantly illegal, and its constitutional arguments to excuse this illegal acts are contrary to Supreme Court precedent and over a century of practice. For the reasons explained below, plaintiff's motion is granted. Plaintiff's termination from the board was unlawful, and Mr. Kaplan and his subordinate are ordered to, Mr. Kaplan is the Republican who's now been elevated to chair, and a subordinate are ordered to permit plaintiff to carry out all of her duties as a rightfully presidentially appointed Senate-confirmed member of that board. She goes on, this is how she ends her 35 pages in her conclusion. The president seems intent on pushing the bounds of his office and exercising his power in a manner violative of clear statutory law to test how much the courts will accept the notion of his presidency that is supreme. Defendants cite in their briefing, Trump versus the United States. This is the Summer case on immunity. Granting the president absolute and presumptive immunity from criminal liability for official acts, to argue that the removal power he has is conclusive and preclusive, with the result that the president need not be subject to criminal or civil legislative constraints. See, they take it that one step further. That the immunity cases were about criminal, not civil. The courts are now again forced, Judge Beryl Howell continues on page 36, to determine how much encroachment on the legislature our Constitution can bear and face a slippery slope towards endorsing a presidency that is untouchable by the law. The president has given no sufficient reason to accept that path here. Humphrey's executor, that case from 1935, and its progeny control the outcome of this case and require that the plaintiff be permitted to continue her role as a board member of the NLRB and her termination declared unlawful and void. The Constitution and case law are clear in allowing Congress to limit the president's removal power, and it's allowing the courts to enjoin the executive branch from unlawful action. Trump's hyperbolic characterization that legislative and judicial checks on executive authority present extraordinary intrusions on the executive branch is both incorrect and troubling. Under our constitutional system, such checks by design guard against executive overreach and the risk such overreach would pose of autocracy, citing Louis Brandeis, a famous Supreme Court justice from an earlier case. An American president, Judge Beryl Howell concluded, is not a king, not even an elected one, and his power to remove federal officers and honest civil servants like plaintiff is not absolute, but may be constrained in appropriate circumstances as are present here. She will enter an order consistent with her memorandum and opinion. What's going to happen next? Donald Trump's not going to like that. We have some various cases all going on at the same time, and I'm going to give you the three and line them up. This case, she used to be the chief judge. She's now a senior status judge. Beryl Howell just ruled on the NLRB side that Trump can't be a king, doesn't buy the unitary executive branch, and says Humphrey's executor controls. We had two other cases in the last 72 hours. Amy Berman Jackson, same court, DC Circuit Court, she ruled that Hampton Dellinger, who used to be until 2 days ago the head of the Office of Special Counsel, which handles labor issues and makes sure that federal workers are protected against retaliation and illegal firings. He himself was fired. Amy Berman Jackson went through a 35-page analysis, also relied on Humphrey's executor, and found that he should be put back into his chair. However, a 3-judge panel of the appellate court that sits over all of these trial judges in D.C., they just ruled that he needs to be removed from his job again while they have a full appellate briefing through April and May. So we have one 3-judge panel, there's many panels of the appellate court, who has not agreed that Humphrey's executor applies. And then we've got a case by Rudy Contreras, who wrote a 35-page decision about a person who was the head of the Merit Protection Service Board, which is also a quasi-independent board like the NLRB. And he also ruled that Humphrey's executor, that progeny in Supreme Court case from 1935, puts her back in her chair, and we haven't gotten the appellate decision resulting on that. That all is a long-winded way of saying we're heading to the Supreme Court. We've got appellate courts that aren't agreeing with the 3 so far trial judges who are all unified and uniform about trying to rein in Donald Trump under the Constitution and their historical precedent. And now the Supreme Court's going to have to rule. I think they'll consolidate all 3 of these cases. The one from Beryl Howell, Judge Rudy Contreras, Judge Amy Berman Jackson, and they'll finally have to. And the fight that we're going to see for the soul of the existential fight on the Supreme Court and for the soul of the Supreme Court, and therefore by extension the rule of law and our constitutional republic, is going to be this fight that she laid out at the very, very beginning in her order about the unitary branch. Let me just read to you from that, because this does lay out what the Supreme Court, 4 people believe in the unitary president model: Gorsuch, Kavanaugh, Alito, and Thomas, and 3 don't, and side with like Cass Sunstein and believe that that's a myth. And then we got to see where Roberts and Amy Coney Barrett, who's quickly becoming the swing vote. It's becoming the Amy Coney Barrett court. And MAGA knows it. They started to attack her. But here's how Judge Beryl Howell so smartly laid it out in the first 2 pages of this memorandum of opinion. On page 1, scholars have long debated the degree to which the framers intended to consolidate executive power in the president. The unitary executive theory, the theory in its purest form that under our tripartite constitutional framework, executive power lodges in a single individual, the president, who may thus exercise complete control over all executive branch subordinates without interference by Congress, has been lauded by some as the hallmark of an energetic, politically accountable government, which is, while rebuked by others as anti-American, a myth, an invented history. That's the battle. And the Supreme Court is going to have to jump into this. We got the monarchists, imperialists of the alt-right 4, and then we've got the 3. What happens with Roberts and Amy Coney Barrett? That's the answer to the question. We'll continue to follow it right here on the Midas Touch Network and on Legal AF. I'm Michael Popak.